I'd like to welcome you all to the first of the Flipper Twilight seminar series for 2013, and I particularly welcome those that are participating on the webinar. They're participating from Eagle Street right up to Cairns and out to Roma. The Magellan program is now a permanent fixture of the family court to decide those parenting cases that involve serious allegations of physical and sexual child abuse. Justice Forrest is the Magellan List Judge for Brisbane. We are very honoured tonight that Justice Forrest has agreed to give up his time to speak to us about the Magellan program, and in particular how better we can present our cases. He's going to discuss certain orders and the management of the program generally. Please welcome Justice Forrest.
Thank you very much, Trent. Thank you to the board of Flipper for agreeing to let me speak to you tonight. I just asked Trent before we started if he had any idea how many of you knew anything much about Magellan, and he really didn't know. It's safe to say that looking around, and I can see that myself, that some of you would be very experienced Magellan practitioners, such as Nikki Davies at the back, and some of you probably less. So would you mind just giving me a show of hands of those of you who have had cases in the Magellan list? Okay, so there's about half of you who know something about it. Is there anyone here who doesn't know anything much at all about the Magellan list? No one's prepared to put their hand up for that? Oh, yeah, James. I won't identify you, James. Well, I just wanted to start by basically restating to you what Magellan is. We actually call it the Magellan Project, although, colloquially we refer to it as the Magellan list. But the Magellan Project is said to be a case management system within the court for cases involving allegations of sexual abuse or serious physical abuse of children, which require particular judicial management and determination within prescribed time standards. I just noticed also that in the protocol for the division of work between the Family Court and the Federal Magistrates Court, in the list of things that are set out as matters that should be filed or heard, at least in the Family Court, one of the matters is listed as serious allegations of sexual abuse of a child warranting transfer to the Magellan list or similar list where applicable, and serious allegations of physical abuse of a child or serious controlling family violence warranting the attention of a superior court. So not all of those things listed in there necessarily meet the Magellan Project protocol, and that's why they said it after referring to serious allegations of sexual abuse warranting transfer to the Magellan list. So I just want you to bear that in mind. I asked Trent could I come and speak about Magellan when he was at a Magellan stakeholders meeting that we held in the court just recently, where Justice Stuart Austin from Newcastle, who's our court's national Magellan coordinating judge, was in attendance. And some of the matters that I'm wanting to just talk to all of you practitioners in general about tonight are matters that arose in that meeting, but others aren't. I wanted to start by contextualising this talk around our list in Brisbane and what's happened to it in the last few years. About 3 or 4 years ago, when my colleague Justice Murphy took over control of the Magellan list in our registry, there were approximately some 127 matters sitting in the Magellan list. Justice Murphy managed the list very well and handed it over to me at the beginning of last year. I can proudly say, and a lot of the responsibility is attributed to Justice Murphy's management of the list, that we now have the list down to 46 unresolved Magellan matters in that 3-year period. That includes a number of matters that have been heard and had trials already where judgment is still reserved. The figure in Queensland represents about 22% of national Magellan list matters. The person in the registry responsible for listing Magellan matters proudly told me just last week that we had all matters that are currently ready for trial in the Magellan list actually listed for trial dates, at least within the next 6 months. But Registrar Tracy Brooks, who's the Magellan Registrar, told me this morning now there is one matter that's ready for trial that is not yet listed. So generally we're going pretty well in respect of the management of them. In respect of the Magellan project, of course, there are 2 ways in which you'll get a matter into the Magellan list in our court, or 2 paths. One of them, of course, is you have proceedings in the Federal Magistrates Court, and the Federal Magistrate will, according to the protocol that exists between the 2 courts, determine that it should be transferred up to the Family Court and at least considered for listing in the Magellan list. Just because a Federal Magistrate does that doesn't, of course, mean that it's going to get listed in the Magellan list. You may appreciate it's not for the Federal Magistrates, with respect to them, to determine what's a Magellan matter and what's not. Our court runs the Magellan list, and our court determines what becomes a Magellan matter and what doesn't. The other way that you can get into the Magellan list is you can file in our court and you can ask for the matter to be considered to be listed in the Magellan list. Now, most of you practitioners know when you are presented with a case that involves allegations of serious sexual abuse or serious physical abuse, that, at least in your opinion, would warrant being regarded as Magellan and treated in the particularly special way that Magellan matters are. So it shouldn't be surprising, really, to see most of the matters coming into the Magellan list coming through filings by practitioners in the registry. One would expect, and we expect to see more of the matters that are coming into the Magellan list coming through the filings in our registry than through the process of being transferred up from the Federal Magistrates Court. At least that's what I would expect from when practitioners are exercising, proper judgment in respect of the management of the matters that they are acting in. I had a meeting with Registrar Tracy Brooks this morning. She will be the first person that in our court that your matter goes to for consideration, whether it's come from the Federal Magistrates Court or whether it's come through the registry having been filed by you, to determine whether or not it gets listed in the Magellan list. Now, Tracy asked me to point out to you that simply filing a matter in the Family Court registry and filing a Form 4 in which you identify allegations of sexual abuse or serious physical abuse will not be enough to have it brought immediately to her attention. If you want it to be brought immediately to her attention, you need to actually file file your documents under the cover of a letter where you say, I think this matter is a matter that should go into the Magellan list, and I ask that it be given consideration for listing in that Magellan list as soon as possible. Or if you don't do that, you at least need to say in the orders that you seek, or you at least need to seek orders that include an order on an interim basis that the matter be listed in the Magellan list. When that sort of order's sought, it will automatically then be managed to be brought to Registrar Brooks' attention within within the short space of time that it would. As I say, if you just file a Form 4 with allegations in it and a supporting affidavit with your Form 4, as you are required to now under the law and the rules, you'll certainly have a registry staff person look at your Form 4 and consider it, but they won't necessarily draw it to Registrar Brooks's attention for consideration to be entered into the Magellan project. I was also specifically asked to draw to your attention that there's no picture on there now. Does that mean that it's a? Oh, does that mean that they're still seeing it though? Okay, I don't need to speak softly. I was just worried that they might have a blank screen, whoever's watching it. Okay. I was asked specifically to point out to you that there's, as you'd expect, been a flood of Form 4s filed since the amendments to the Family Law Act in the middle of last year came into force in respect of the family violence amendments. And I have been particularly asked by both the registry staff, including Registrar Brooks, but also also staff members of the Department of Communities, Child Safety and Disability Services, to make a special plea to you all on their behalves to seriously consider how you draw your Form 4s. Apparently, they're getting a lot of Form 4s that they really aren't able to make much sense of, and they want practitioners to be far more particular in the way they draw their Form 4s, particularly the allegations of violence or abuse that are particularised in them, and also in the affidavits that you draw that are filed along with the Form 4 when you file them. The department particularly was very concerned about it because all of the Form 4s have to now be sent off to the department, and they're dealing with a flood of them that they never used to have to deal with, and having particular trouble dealing with them appropriately. So I make a special plea on all of their behalves, and including on behalf of the judges, that you exercise extreme care and precision in drawing Form 4s. Please don't just draw a Form 4 because your client comes in and tells you that something happened that you might think remotely falls within the definition of family violence, as extended as it has become through the amendments last year. You still need to exercise your professional judgment, in my view at least, to determine whether or not it is appropriate to be putting in a Form 4 in the particular case. Because, as I've said, the Form 4s take up time in the registry, they take up time at the department, they require particular responses from the court, so they take up time, they take up money, they take up a lot of resources. So only use them where necessary in appropriate cases after having exercised your professional judgment that they should be used. Now, I understand that only the Form 4s get sent to the department, not the affidavits, not as a standard process, the affidavits that are filed with them. The affidavits will only go to the department if the person in the registry who's responsible for sending them to the department considers that the department won't be able to make much of the Form 4 without the affidavit that goes with it. So, as I say, it's really important to make sure that your Form 4s are appropriately filled out. Now, the process in respect of a Form 4, you may know, is that if you file one within the family court, that it'll be listed to a docket registrar for consideration within 7 days of it being filed. If you file one in the Federal Magistrates Court, it'll be listed to a Federal Magistrate for a first return within 8 weeks. Now, if you are in a Federal Magistrates Court matter And when it gets before a federal magistrate, there is some talk. When I say some talk, I mean bench to bar, bar to bench. You know, that's the sort of talk I'm talking about. When there's talk between bench and bar about whether or not it's a Magellan matter, or whether or not, and I'm not now just, you know, moving slightly away from Magellan, the Magellanists, whether or not it's a matter that should be transferred to the family court. I urge you, particularly on behalf of the judges of the family court, to be actively, professionally involved in that process. Don't simply sit back and leave it entirely to the discretion or determination of the federal magistrate. If you have already exercised professional judgment, particularly at the point of filing or at receiving response from the other side, that the matter is a matter having regard to the Magellan Protocol and the protocol for division of work between the two courts, that is appropriate to be heard in the Federal Magistrates Court. Be actively involved in the process. So when I say that, I mean think about why you're there, why you filed it in the Federal Magistrates Court, and, you know, courageously make your submissions for or against the notion that whether it should be transferred up to the Magellan list or transferred to the family court for consideration to go into the Magellan list. If you thought that it wasn't a Magellan matter when you filed it, don't, without some courage and professional behaviour, allow it just simply to be sent to the family court to go into the Magellan list, or for consideration to go into the Magellan list. Now, and I say that with absolute respect to the federal magistrates, but, you know, you have responsibility that you should not just cede by simply standing back and going, oh, okay, if you're going to send it up, send it up. Be conscious, particularly, of the provisions of Section 91 capital B of the Family Law Act and the provisions of Section 69ZW of the Family Law Act. Most of you would know Section 91 capital B is the section of the Family Law Act that allows the court to request intervention by the Director General of the Department in proceedings, in parenting proceedings in the court. Section 69ZW, that is a more recent addition to the Act, is the section that allows the court to make requests of the Department for particular information. Now, the Department, again, expressed concern at the stakeholders meeting that they are getting 91B requests that they think are meant to be to elicit reports and information from the Department, as opposed to actually getting the Director General of the Department to intervene in the case. So, if a federal magistrate in that court starts talking about 91B intervention, or if they start talking about 69ZW, be across those sections and what they provide for, and understand what it is that you want and that you consider is appropriate, and again, be professionally courageous. If you don't consider that it's a case that requires the intervention of the Director General of the Department, and remember, you're going to be acting for one of the parties, one of the parents. And if the federal magistrate starts saying, well, I think this is one where the Department should intervene, and you don't think it is, be courageous about making that, about submitting that it's not. Because, as I said to you, the Department considers that they're asked to intervene in cases, where they shouldn't be. And I know that there's a lot of argument that they don't intervene in cases where they should. But the problem is that if they get swamped with requests under 91B to intervene, and many of those cases they consider are cases where they shouldn't, then they don't give the appropriate attention down at the departmental level to those requests that are made, like in Magellan matters, when they're in our list, in the Magellan list, for them to intervene. Now, the other thing you might want to consider if you're before a federal magistrate and the talk turns to Section 91B and the intervention of the department. You might consider that if a federal magistrate considers that 91B ought to be invoked and a request sent off for intervention, you might want to make the submission to the federal magistrate. You might, but especially if the federal magistrate's talking about it being a Magellan matter, you might want to make the submission that the determination of whether a 91B request should be made might be better left for the court that it's being transferred to, if and when the decision's made for it to be put into the Magellan list. So just bear that in mind. I'm aware that there may be a view in the Federal Magistrates Court that the Director General should be invited to intervene in cases even if they're not Magellan matters. Of course, no one can interfere with the judicial independence of the Federal Magistrates, and generally they're working with busy lists and have difficult jobs. But please, don't hesitate in appropriate cases to be making submissions to them in respect of these matters, and especially where it looks like it might be coming up to our court, to hold off on the request for intervention by the department, or to more appropriately consider requests under Section 69 ZW for information to be provided. However, as Tracy Brooks said to me this morning, it's a difficult, one of the problems for her in getting the matters, when she determines that a matter's a Magellan matter, one of the problems in getting it listed before me for directions quickly is that if she then decides to appoint an independent children's lawyer, it takes a long time for an independent children's lawyer to be appointed and come up to speed on the case. So that then puts an immediate delay in the process of several weeks. So if you're in the Federal Magistrates Court, if, for example, you're in a case where you didn't know sexual abuse allegations were going to be raised, but the other side raises them, and you both agree before you even go in that yes, this is a matter that probably should be considered for the Magellan list and transferred up, please don't hesitate if you also consider that an ICL is appropriate in the case to make the submission that the ICL should be appointed at that stage at the time of the transfer, because that then gets the ICL appointment process underway, and by the time it gets to Registrar Brooks, that process is well and truly underway, and it then can be listed before me in the directions list fairly soon thereafter, with an expectation that an ICL is going to be involved and know what they're doing by the time it comes on for directions before me. I want to stress though, notwithstanding that you've got a choice, when you file a matter, you stand firmly at the gates of really two courts, choosing which court you wish to file your application in. Your decision should be made on proper professional grounds, having regard to the facts and instructions that you hold in the case that you're in, and having regard to the protocols that exist as between the two courts in respect of the division of work, and having regard to the Magellan Protocol. Decisions should not be made on the basis of what we all know as forum shopping. Be aware that just as matters can be transferred to the family court from the Federal Magistrates Court, they can be transferred back. Even, if Registrar Brooks gets a hold of a matter that's been transferred up for consideration in the Magellan list, and she doesn't think that warrants being listed in the Magellan list, or even in the family court at all, then matters can be transferred back to the Federal Magistrates Court. We in the family court in Brisbane have taken some pride in the fact that we tend to try not to get involved in judicial ping-pong, particularly when we're dealing with litigants who have, in some cases, been waiting around in the Federal Magistrates Court for a long time for a hearing before they're transferred up to our court. And we've tried to avoid using our powers to transfer matters back, but where we consider there might be some forum shopping going on, or where it's completely inappropriate for the matters to be heard in our court having regard to the protocols, then we won't hesitate to transfer matters back. Now, if I can just move to the first court event that will be before Registrar Brooks in the Magellan list. She deals with the matter on the first day in her chambers. She'll determine whether to classify it as Magellan. She'll appoint an ICL if it's not already done. She'll request a Magellan report from the department if that hasn't already been done via Section 69ZW. She'll deal with the request for issue of subpoenas. She'll list the matter for an interim hearing before a judge or the principal registrar if that's required, or stored in the application that's been filed. She'll list then the matter for directions in front of me. And as I say, that's best done at a time when there's already an ICL involved. Registrar Brooks told me today that she's even making it a standard order now that particularly the ICL, or I think she's putting the obligation or responsibility on the ICLs, but in conjunction with the legal representatives of the parties in Magellan matters, for them to come to the directions hearing in front of me where it's at all possible with an agreed set of draft directions for me to consider and make on the first directions hearing. I had a directions hearing list yesterday and I had 3 matters, and certainly in 2 of those 3, and the other one there was a good excuse for it, but certainly in 2 of those 3 the ICLs were ready with their draft directions that had been shown to the other parties, and the process was made far easier than it might otherwise have been. That's an expectation now in each of my Magellan list directions hearings. You need to consider, both at the first directions hearing before Registrar Brooks, and if it hasn't been done or things change between then and when it comes before me, you need to be ready to discuss issues such as the decoupling of financial proceedings from the parenting proceedings. When a matter is in the Magellan list, if it has property and financial applications that are part of the same application as the parenting application that has warranted Magellan attention, you can have no expectation that the property and financial aspects of it will proceed at the same time as the parenting case. In other words, be aware of the fact that in management of the Magellan list, we will not let the process of getting a Magellan parenting matter to trial as quickly as we possibly can be dragged backwards or slowed down or somehow inhibited by property and financial matters that are attached. When I say decoupled, they'll effectively, when Registrar Brooks and myself are managing the Magellan matters through to trial, if you say, oh, but the financial matter's not ready, we've got to find evidence of this and that, don't expect it's going to slow down the listing, or the readying and listing of the Magellan matter for hearing, and they'll have to be dealt with at a later time. So that's another matter you need to consider when you're getting instructions, drawing your applications, and determining whether you're going to seek to have the matter listed as Magellan, whether it's going to go into our court or not. Another thing that you'll be asked to consider, particularly if you are acting as the solicitor for a parent who is alleged to have sexually abused children or a child, or even seriously physically abused them, and who has been charged, coincidentally, with criminal proceedings as a consequence, that there is no standard practice or procedure on the part of our court that says, whilst those charges are pending and haven't yet been determined, that the Magellan matter gets parked and put in abeyance and in a waiting list until some indeterminate time in the future when the criminal proceedings are finalised. That is really a matter for your client. You need to discuss that with your client. I haven't experienced it here in Brisbane, but Justice Austin tells me of a number of cases that he's had where parents in Magellan matters who have been charged criminally, who haven't had their criminal proceedings finalised, have still been adamant and determined to proceed with the parenting case as quickly as possible and happy to give evidence in the parenting proceedings well and truly before they've even got near a criminal court. And he told me of a case where he understood it after having heard and decided the case. He understood the man's position on that because he found it was a load of concoction, and so the result in the parenting case probably had some bearing on what happened in the criminal proceedings. So don't automatically work on the presumption that your client's interests are best served necessarily by parking the Magellan proceedings and waiting till criminal proceedings are dealt with, and certainly don't work on the basis that the court expects that or requires that. So be ready for either Registrar Brooks or myself at the directions hearing to, ask in a situation like that what your client's desires are or what you really want to do in respect of that. When you do come before me at a Magellan List Directions hearing, you should start with the expectation that I will know about the case. Don't come in thinking that I don't know anything and that you need to tell me all about the facts and what the allegations are, etc. I get well briefed with a memorandum that summarises it from Registrar Brooks, and it'll include all of the history of the matter if it was in the Federal Magistrates Court, including all the orders that have been made. It will include summaries of Magellan reports obtained already from the department, child notifications, child abuse notifications and the like. So I read those before I go to the directions hearing, so I'll know about the case. You don't need to take me through stuff that I already know. You will, though, need to tell me, if you can narrow them down, what the real issues are, what the real dispute is about. You will need to tell me what's proposed to ready the matter for trial as quickly as possible. You will need to tell me what's already been done to ready it for trial and what's been finished. You will need to tell me how long the things that are yet to be done are going to take. Now, one of the biggest delays currently in the Magellan List in Brisbane, and not just the Magellan List but other parenting matters in our court at least, and I expect also in the FMC, is the lack of experts who are prepared, and I mean psychiatric experts, psychiatrists, and family report writers, particularly private family report writers, who are ready, willing and able to make their services available to the parties, particularly psychiatrists. And one of the main reasons why we're not meeting current Magellan protocol expectations in respect of time frames is particularly the difficulty of getting experts. We're working on that as well as we can. You can assist by, in your own inquiries and practice, seeking out and obtaining and retaining psychiatrists who are experienced and qualified and well enough to do reports and are willing to do them. You can also assist by making sure that you treat them appropriately in respect of the whole process. Last year I was told by a very senior, experienced psychiatrist who, when I was at the bar, I worked with from time to time, who was a very capable expert witness, that he was no longer doing family court, medico-legal reports because of the way he'd been treated by the practitioners in a case who just rang him up and said, "You got to be here tomorrow to give evidence," when they'd given him no notice of that before. I'll come back to that issue a little bit later. Be ready, if it hasn't already happened, be ready for me to discuss with you the decoupling of any financial matters and that issue about the criminal offences. be ready to tell me what should happen next, whether it's going to go to an interim hearing, whether it's got to come back to me for further directions, or simply go to the Magellan Registrar again for trial directions. And if you, at the first directions hearing before me, are satisfied that the matter's already ready for trial, or is just about, don't hesitate to ask me to make the trial directions so that it can be made ready for trial as soon as possible. Also, you need to be aware of the fact that we can declassify a matter from the Magellan list and say, oh, it's no longer Magellan even before it gets to trial, and send it back to the ordinary list so that it doesn't get any special treatment. You might say, how can that happen? But there are cases where allegations are sometimes abandoned expressly or even by implication by one of the parties. For example, if a parent who's made allegations of sexual abuse agrees to an interim regime where the children spend unsupervised time with the other parent, one might think that they've, by implication, abandoned the allegations, and that case could very well be declassified from the Magellan list. It may also be that a judicial officer who's heard an interim application, I don't expect this would happen very frequently, but it may be that a judicial officer has already heard and made some determination rejecting allegations, and therefore creating a situation where it could be declassified as a Magellan matter. Now, just in case you didn't know, the system we currently have in place in respect of listing Magellan trials is that they of course bypass the normal call-over process. We now have designated quarantined Magellan weeks, at least every 6 to 8 weeks, and in those they're blanked out in our calendar, for several months in advance, many months in advance, and the matters are put into those weeks through the registry staff, through Registrar Brooks and Kim Hopwood, and they're put straight into the Magellan list once Registrar Brooks has determined at one of her directions hearings that all of the matters that need to be attended to already, the matter for trial, are in fact completed. We are generally listing 3 judges in each Magellan week, and because we are listing 3 judges, we are over-listing Magellan matters in those weeks, sometimes with up to 2 reserved Magellan trials, but generally at least 1. You would be surprised with the number of settlements that you get in a Magellan list, even in cases where there's serious allegations of sexual abuse or physical abuse. You would be surprised with the number of matters that actually settle in, either completely or in some significant way, either just a few days before or even on the door of the court on the day of the hearing. So we find that we can overlist in those weeks. If the matter doesn't get reached, of course, it'll be given priority in the next available quarantined Magellan week. Whilst I'm talking about listing, I just want to digress briefly from the Magellan list and talk generally about listing arrangements in the Brisbane Registry of the Family Court. We've got a system now. You may know Justice Kent is now the case management judge, or list judge as we call him, responsible for the listing, and he has taken over that job from Justice Murphy as well. He's been doing call-overs in the same way that Justice Murphy did, but currently we're looking at, in conjunction with the other registries around the country, where we're trying to standardise the case management process, particularly Sydney, Melbourne and Brisbane, that seem to have developed their own cultures over the years. We're looking at maybe tweaking the system just a little bit in the near future, but more of that later if it happens. But the listing system, the case management system that we do have, I wanted to, tell you at least, and with the support of my colleagues, I've been asked to tell you that our current listing system really does reward parties and legal representatives who are efficient in getting their matters ready for trial as quickly as possible. Once you come into our court, you're in a list of a registrar's docket, as we call it. The registrars generally manage the matters with the assistance of the judges if they need it. If there's recalcitrance or anything like that needs some judicial prodding along the way. But the registrars generally will case manage a matter until it's ready for trial. When they are satisfied it's ready for trial, it gets put, we have a meeting every month or every 6 weeks. All the judges in the trial division in Brisbane, and all of the registrars, and we sit around, and the registrars each go through their list of matters that they say are ready for trial, and we will then we then allocate them to judges and trial dates. Now, there is no question about matters having to wait in the queue behind other matters that aren't ready. Right? No, so you don't have to wait in a long queue if you're ready behind anyone else who's not. So if you come into our court either by filing in our court or transfer from the Federal Magistrates Court, the sooner you have the matter ready for trial, the sooner you'll get a trial. And that's something that I want you all to take away. So I know that you're only one side of the equation, that either you'll have a practitioner on the other side, and in plenty of cases these days you might even have a litigant in person. And in those cases, well, you may feel as if the matter's not being ready for trial as quickly as you are readying it for trial. In those particular cases, if you've got concerns that a practitioner on the other side or a party on the other side is delaying, stalling, deliberately doing that, and trying to avoid having the matter listed for trial as quickly as possible, then you must take that up with the registrar and make noises about that, including if you think the registrar is not acting proactively enough on it, listing it, asking for it to be listed in front of one of the judges to take some steps to deal with what you say is recalcitrant behaviour on the other side. Because if they're holding it back and it's determined that they are, well, steps will be taken, of course, to make sure that the recalcitrants are pulled into line and the matter is readied as quickly as possible. But there's no reason why, when you're ready for trial, that the matter shouldn't get listed as soon as the next caller, really. Because we had a call-over meeting at lunchtime today, and the registrars, all of them presented all of the cases that they say they now have that are currently ready for trial. And every single one of those got listed, and if from memory, I think the furthest listing out would have been September. Right? So our listing system, we believe, now rewards the efficient practitioner, the practitioner who really does want to get their matter on for hearing. Just a few things that I wanted to finish with that I ask you to remember in respect of both Magellan matters particularly, but also other parenting matters that are heard in the family courts. Remember that last year we sent out a notice to the profession that sets as the default position in parenting cases, including Magellan cases, that experts who have provided reports are to be the first witnesses heard in the trial, so they know the day the trial starts from several months prior to the trial starting, and they know that on the day the trial starts at 10 o'clock or 11 o'clock or 12 o'clock they're going to be heard. The other default position is that they're allowed to give their evidence by telephone. Now, those default positions exist unless otherwise agreement is reached between all of the parties. And I urge you, when considering agreeing to something other than that, to take the witnesses' views, particularly if they are busy private professionals such as psychiatrists or psychologists or social workers in private practice, and even family consultants at the court, because they may have things on the morning, they may have things booked already. So take the expert witnesses' views into account before you decide to move from the default position. And if you can't reach an agreement on a change from the default position, and you consider that in the interests of justice a change is required, you should be making application to the court well before the trial date. Do not leave it to the morning of the trial. Another matter that I also want you to remember and to think about, particularly in the Magellan list, is always check for the existence of digital video recordings of interviews between police and departmental officers and complainant children, and between police and alleged perpetrators. If they're in existence, know that they are, so you can tell the court. Make sure that they're available for the trial. Make sure that you've watched them, that you've taken into account the length of them, especially in your trial plan, in working out and advising the registrar and the court how long the trial should be listed for. And make sure, if you're going to be relying on your own electronic digital recordings from your clients of various things and bringing them along and having, seeking to have them admitted into evidence, or even if we're talking about police digital recordings, make sure that they match the technology that the court's got for playing them. Justice Bell had a matter in his court just, I think, yesterday or the day before, where something was sought to be played, and it took some 3 hours to get the technology because there hadn't been a check done beforehand by the practitioners involved that what they had and wanted to play and put into evidence actually was able to be played and properly viewed and heard on the technology available to the court. Trials shouldn't be delayed by that sort of thing. That should all be sorted out before. And it doesn't cease to astound me when I've got Magellan trials that I'm hearing, when I'm told, even by ICLs and their counsel, we haven't seen we haven't watched any of the videos. You really should, especially ICLs, in my view at least, you should be at least have watched those videos, and if you don't intend to put them into evidence, you need to be able to inform the court why and what was the basis of your decision about that, in my view. Tracy Brooks asked me to just tell you that there's no point trying to annex CDs to affidavits to file them. She told me the court won't take CDs as annexures to affidavits, only documents. Even if the CDs contain long lists of documents, as I know they sometimes do these days, in complex financial cases. But, they're only to be tendered as exhibits at the trial, so don't try and do that, she said. Plan with the other parties and in conjunction with the registrars when trial directions are being made. When digital recordings of interviews or anything like that are actually going to be played in the course of the trial, and in my view they probably should, if they're interviews, police interviews or departmental interviews, they probably should be played early in the trial after the experts. It may be even that an expert, like a psychiatrist, should see the videos. So, consider that aspect of it. And if that determination's made, then sort that out and make sure that you plan for it and that it's all organised. Another bit of a bee that I have in my bonnet, and I know the others, my colleagues have as well, is in respect of documents being tendered, particularly from subpoenaed documents in the Magellan cases like police records, departmental records, school records and the like. Be as well organised in respect of the documents that are going to be tendered as you possibly can. Try as hard as you can to reach agreement between all the parties as to what should be tendered. Do it if you can in a ring binder, where all the documents, the photocopies of the documents are paginated, tabulated and indexed. But make sure, if you possibly can, that only the material that you will either refer a witness to in cross-examination or refer to in submissions is included in the documents that you want to tender in that bundle. Judges do not want that thickness of photocopied documents from departmental files and police files tendered into evidence if they're not referred to in cross-examination or they're not going to be referred to in the submissions made at the end. You tender them into evidence, there comes with that an expectation, if not an obligation, that the judge is going to have to read them, or that you want the judge to read them. But if you haven't put any of them to a witness in cross-examination, or in chief even, or if you haven't referred to any of them in your submission, then why should a judge read them with respect? So just be conscious of that. And finally, I think this may have been said before, but finally, we judges on the family court, particularly in parenting cases, want all of the parties, and not just the parents, but ICLs as well, to be as ready as they possibly can in all the circumstances at the start of the trial to tell us what are the findings that they expect the judge to make at the end of the trial and what orders they would expect those findings to support from the judge. Now, in respect of ICLs, we don't want to just keep seeing ICLs saying, well, we don't know what we want till we've heard all the evidence. Now, if it's a sexual abuse allegation case, then there's no reason why an ICL at least can't say, well, if this finding is made, then this. But if, on the other hand, this finding is made, then this. But if the evidence that the ICL has gathered in the form of the expert reports is sufficient to persuade an ICL, properly discharging their independent objective duty, to consider that certain findings are likely to be made at the end of the trial, then we see no reason why an ICL particularly can't say that at the start. We of course appreciate that there is there are many cases where the interests of justice and the course of the trial would require a different position taken at the end than one that might be adopted provisionally at the start. But we don't want to see continually cases coming before us, particularly in the Magellan list, where we're just simply told we don't have a position, we want to wait and see what all the evidence is. Now, I don't know what the time is, if there's time left for questions, but if anyone has any, I'm more than happy to answer them. Mr. Linklater-Steele.
Of the matters that are set down for trial, how many matters actually contain an evidence by the department?
I can tell you I don't know of any, actually. That's not to say that there aren't, but at the moment I don't know of any. In fact, there was one that was put into the Magellan list fairly recently involving a serious allegation of physical abuse, where the department was involved from when the child was taken to the hospital, and the department did intervene. At the time it came into our list, there was a state order in place. The department intervened. The matter went before the principal registrar on Tuesday, and she made orders, of course, that placed the child with the parent who the child's already with. So live with orders that come into effect, she said, when the state order doesn't apply anymore. And the matter was then sent into my directions list yesterday, and I read the document, the briefing that said the department had intervened, and I said, where's the department? To be informed that, they're out now. They don't want to be in it anymore, now that the order's been made.
say that procedures things happen fairly regularly? Is there some protocol at a national state level where the situation seems to be repeatedly arising where they don't intervene, they intervene for a little while then run away, but they still hold over various clients the idea that unless you act protectively, we at the end of the trial, not having participated, may come in and either take or remove the charge.
Well,
Is that being made
I can answer that question at least in this way, I think, James.
Excuse me, Judge, can I just ask you to
Stand back a bit. Oh, right.
On the webinar here.
The question, if I understood it appropriately, was is there anything being done to try and somehow encourage the department to actually intervene in more cases where they should, rather than just hanging as a spectre or a sort of Damocles on the outside over the heads of heads of parties, with veiled threats of acting in certain ways if the parties act in a certain way. Is that a fair enough way to describe it? We are working on it. As I say, we recently had a meeting of stakeholders, which included people from the department. The process, the process started. Part of that process is what I've spoken to you about tonight, particularly in respect of 91B requests. So, we have a part to play in it as well. The process will continue. The protocol that exists, the written protocol that exists between the FMC, the Family Court and the Department in Queensland in respect of parenting matters and in particular Magellan matters, is currently being reconsidered in the light of a recent report that hasn't yet been made public, but has been finally issued, that was done by Professor Richard Chisholm, who used to be a judge of our court. So the protocol is going to be rewritten, and our Principal Registrar, Angela Filippello, and the departmental people responsible are going to be involved in the rewriting of that. Someone from the Federal Magistrates Court will as well. Our concerns about the lack of intervention in appropriate cases will be raised in that process. That said, the department has a limited amount of resources. Speaking as objectively and non-controversially as I can, you would all know what's happened in Queensland in the last year with respect to the resources made available to the State Public Service, and the department is not, doesn't miss out and hasn't missed out there. There's an inquiry currently underway and soon to finish into the department and its approaches to child protection matters. Who knows what that'll say? You and I both know, James, what sometimes happens when the department gets in, when it intervenes in cases. And for those who don't know, James and I were both counsel in a matter that went to trial several years ago that lasted 50 days, that had serious child sexual abuse and parental alienation allegations, where the department intervened, and I had to brief for the department. James was counsel for the independent children's lawyer. That trial went for 50 days. It's probably fair enough to say that the department, as light as I was on my fees, the department felt a bit stung in the end by how much it had to pay in a case that they thought was only going to go 2 weeks. So I dare say that once bitten, twice shy as a result of that case. So not that it ever gets thrown back at me, but you might know more. You've been working with them more recently, James. But I hope that answers your question. Are there any others?
I've got two from webinar participants. Claire Data does Donna have any draft Magellan directions you would like us to use today when drafting our directions for the directions hearing?
Well, I don't have any myself, but I know there are a whole set of them floating around that Justice Murphy prepared. I would have thought Claire might have access to those, working at the Legal Aid Office, but if she doesn't, and she'd like a copy, and I'll have a look and see if I'd make, if there's any I can add or change, and I'll make them available. I could even make them, we could we could make them available through the FIPA website, couldn't we? Yeah, I'll just check with Justice Murphy that he's okay with that. He has done a very good set. So
there might be some on the website.
already? Do you think they might already be there? So just
We'll check those.
Claire, they might. If you have a look at the. But you're talking about me, I suppose. You're asking me if I've got any. I don't at this stage, but I'll have a look and see if there's any particular ones I want.
And David Bearden asked if matters proceed for trial in the Magellan list before the criminal trial does the person giving the evidence get a certificate for immunity from prosecution? The relevant section escapes him at this
Section
time.
128 is the evidence act. And David, you would know as well as I do that the answer to that is if the provisions of Section 128 are satisfied and the judge considers it appropriate. But I can't say yes, they do in every case. Regan.
The decoupling of the proceedings, would you consider sending the property aspect back to the FMC?
The answer to that is yes, probably. If it wasn't one that needed to stay in our court, yeah. Once they're decoupled, yes. Yeah, if it's a what do we sometimes describe them as with respect to small garden variety property division, which they often are if in connection with a sexual abuse allegation, and if they're decoupled, yeah, it could easily be, the property matter could easily be sent back.
Well, Judge, you started off talking about serious allegations of and of course,
I like the emphasis.
serious controlling family violence, which flows from the 2012 amendment. And then, my question here is not one that I'd like you to evade.
What did you say? Not one you'd like me to evade?
Evade with a piece of string on it. What specifically?
I'm a judge, not a politician.
What specifically Registrar Brooks' key criteria for deciding what's serious and what's not?
Oh, I can't evade it.
I mean, it could be said that any form of child sexual abuse is serious.
Well, could be said. Most people say that.
Yeah. So is that automatically a abuse allegation?
Well, a sexual abuse allegation can be. He looked in the window at me while I was in the shower.
Yeah.
What would you think? Would that be serious enough to go into the Magellan list on its own?
Well, it depends if it was affected by serious controlling family violence too.
Well, we certainly haven't got a list of criteria, no.
In your head?
No.
Is there?
No, well, we just use our own judgment.
Oh, thank you very much. Okay.
Yeah, that's what we have to use.
Yeah, I appreciate that.
For those who are interested, 46 Magellan matters currently stage. 3 of them are at first Magellan directions. 11 are awaiting psychiatric assessments, expert reports, interim hearings. One matter is awaiting trial dates after being readied and having trial directions made. 19 are currently listed for trial. 6 have been heard and are reserved. 6 are in the category of what we call parked while criminal proceedings are taking place. 21 of those are under 12 months. 15 are over 12 months and under 24 months. 6 are over 24 months. 4 are over 36 months. And the Magellan protocol expectation is 6 months from coming in to going out. So we've got a bit of work to do yet, even though we've got the list down to 46. Another bit of information I was given today by Registrar Brooks. In 2008-2009, so the financial year, there were 157 direct filings into the family court, 246 transfers from the Federal Magistrates Court. In 2009-2010, 138 filings into the family court, 229 transfers from the Federal Magistrates Court. 2010-11, 262 direct filings in the family court, 237 transfers from the FMC, and in 2011-2012, 199 direct filings into the family court, and 303 transfers from federal magistrates. So we've gone from a total of filings and transfers of 403 up to 502. So a 20% increase in those 4 years, and probably about a 30% increase in direct filings in the family court in those 4 years.
I won't even begin to speculate on what the reasons for that might be.
Mr. Linklater Steele, another one.
Representing some of my colleagues.
What are you charging?
Is there any consideration to the court reducing the cost of subpoenas for ICLs? Because invariably the ICLs would have to issue the majority of the subpoenas in Magellan matters, and the recent increase is that you've just seen several ICLs just not have enough money to satisfy their task. Secondly,
Tell me about the cost of subpoenas. What is it?
$40. $50
To file a subpoena? But the filing fees are set by the government, aren't they?
yes, but under the project, one might think that a dispensation might be able to be achieved, that ICL would have to do all the legwork.
Hasn't the government recently imposed an actual fee on ICLs as well? For being involved in the case? Do you know, Nikki? Is the fee on ICLs just on subpoenas?
Yes, that's right.
Right, okay.
The other aspect
But filing fees, so if the ICL files any other documents, they don't get charged. I think at the just in answer to that part of it, at the stakeholders meeting, didn't Justice Austin say there's some work being done on that? See, it's not something the court set. The court can determine the filing fees. But the court, to answer your question, I don't know of any particular things that are being done, but I understand, as Nikki just said, that there is lobbying going on at national level for the government to reconsider that aspect of their of the fees that they've recently hiked.
And the other question is there a possibility that we could get a standing direction?
Oh, can I just add to that? Submissions from Flipper to the government, to the Attorney General's Department, would be a good thing to do in respect of that, no?
Just on the other thing, as a standard direction, and having a technical justice officer recently, in other jurisdictions they get a standard direction that all parties, or certainly all legal practitioners, can copy the subpoenaed material.
Yeah.
We don't have a situation that the ICL is the only person to gain a copy of a complicated sexual abuse matter, and there's no continuing release that is continuing permission. There's some direction that might be able to be given potentially restricting copies and versus to the legal practitioner. Avoiding the idea that a self-represented person might gain material that they perhaps would not have at one stage.
Yeah, sometimes the problem is they don't have it because with delayed trials they come along and say, well, I haven't been able to have any of these documents.
I appreciate there might be a discretion, but the fundamental problem is the ICL is the only person invariably that gets the ability to copy, representing people, to try to manage the documents which are hypercritical in most Magellan matters.
I'd say the answer to that is that it's a relatively easy matter to fix, James, because the registrars deal with the subpoenas, don't they, make the directions about who has leave, etc.?
Yes, they do.
Well, I could just have and it's Tracy in the Magellan list, Tracy Brooks. I can talk to Tracy about it. Yeah, I can talk to her about that, make some suggestions to her. Can't tell her.
Quite a copy order, and I was prepared to give an undertaking to use the copies only to brief counsel.
Well, I'd simply say this. I'll talk to Tracy about it. I've taken a note about it. And if you're still confronting the problem at the first directions hearing in front of Registrar Brooks, then raise it with me at the first, as a matter at the first directions hearing in front of me. because frankly, you won't have to do much to convince me that each side should have access to the documents. You'd need to do more work to convince me that someone shouldn't. Frankly, but I've had cases where the litigants, you need, those of you who are ICLs would know. So many Magellan cases that we hear, there's an ICL and a barrister that the ICL briefs in the middle, and on either side of them, litigants in person, mum and dad in person. And so often they say, well, we haven't had access to the documents. Sorry, I shouldn't grumble myself. But that's what they say, and then there's a delay while we stand down and they get copies given to them, etc. Anyway, so I certainly am of the view that the onus should be the other way. It shouldn't be only the ICL gets access to the subpoenaed documents and photocopies of them. I say, in the interest of justice, all parties should, unless there's a reason shown why they shouldn't. Any more questions?
Just a comment from Damien Greer that there's a recent decision that provides that ICLs are exempt from filing fees for subpoenas.
Oh, decision. Nikki.
It's not binding.
No.
Can I say, in Tasmania, the Legal Aid Commission in Tasmania is not funding ICLs for those fees, and they are actually turning up to the that judgment trying to tell the staff that they shouldn't have to pay the fee, but of course the government employees are directed to take the fee.
It's not a great state of affairs, I can assure you.
The Legal Aid Commission is currently funding ICLs to pay the fees for unlike some of the information.
It's certainly not something that I personally support, that ICL should be charged for subpoenas. No. So wherever I get a chance, I'll make my views known for what they're worth. Anything else?